Today, we're going to cover transferring real property to your children and how that gets affected for real property tax purposes. So the scenario is that you have one example, 1 to 3 children, you have a house in that estate plan, and let's say you have 3 children, at least one of them has decided to live in the house and keep the house rather than selling the house after your death. So you're trying to build it into your estate plan so that the beneficiary child who receives the house can still afford to keep it after the draconian increases recently in Proposition 19 against families maintaining their home for the long term. So we're going to get into all the details on how this Proposition 19 works. So in February 2021, there was a change in the law. The effective date for the Proposition 19 to come in effect. It was passed by the voters in 2020, and there were several provisions in that proposition that talked about other issues, and it purposely hid the fact that it was going to destroy a lot of families' estate plans. And I think it was one of the biggest proposition voter fraud cases that I've ever seen in California, because no one knew they were voting for this huge property tax that thwarts you from giving your house to your children. So the law changed effective February 16, 2021. We're going to cover how it works now and not go into great detail on prior rules. It applies only to your principal residence and not to rental property. So we're trying to exclude property tax in California is based on value, assessed value. So, excuse me. So what we're trying to do is keep that assessed value low and allow that to be transferred to your children as your property tax is now. The exclusion, the maximum amount that can be excluded without an increase in property tax is 1 million. By that I mean if your child fills out the proper papers, you can get an exclusion from reassessment on property tax up to 1 million. And we'll get into the details on how that actually works. Oh boy, I got a bit of a cold today. So what we have is we have a sale or purchase or inheritance. What happens in real property tax in California when someone dies and they own a house, if it's a couple and the surviving spouse dies, that creates a change of ownership. Change of ownership on real property for California real property tax purposes is an event that causes reassessment of the property taxes. So it's either on a sale or a gift. Boy. And it doesn't matter whether the transfer was voluntary or involuntary. What it means by involuntary is if you die and it changes title. Voluntary change of title is when, for example, you sell or give the property to a beneficiary in this case. Who's eligible transferee for this property tax exclusion? A child born of the parent who owns the property, a stepchild of the parent, and a child-in-law, an adopted child, a foster child, and as we'll see, this rule also applies to grandchildren, but the grandchildren's parents have to be deceased in order for it to work. So another way to say the parent-child exclusion is intergenerational transfers. So, because that includes two types. One is parent-child exclusion, the other is parent-grandchild exclusion, combined as intergenerational. It can only be the primary residence of the transferor, and within 1 year of the transfer, change of ownership, the new owner needs to establish this property as their principal residence. There's a form for that called the homeowners exclusion, which we will show you. Oh. The forms that will be filed in order to claim this exclusion is these BOE means Board of Equalization. They're kind of supervising the California Revenue and Taxation Code laws for real property tax. And so we got the BOE 19P and then another one G, one for parent-child, one for grandchild, and then another one for homeowners exemption. If the county sends the new owner a notice of supplemental assessment, then the beneficiary has to take quicker action within 6 months to claim their exemptions. And the lien dates, you can claim these opportunities for a certain limited period of time. Within 1 year of the date of death is when you need to fight for your homeowner's exemption, and you have to have the entire transaction taken care of before you give or sell the property to a third party. So the example here is someone's died. Their child is now going to receive the property, child or children. You can have 2, 3, 4 children on title. And we want to keep the property tax low. So we have this form to fill out and file with the county assessor in your county in California. So it describes the property that you are excluding or claiming the exclusion on, that you have to state that it's going to be the transferee or child's principal residence, whether they're going to claim a homeowner's exemption, or if they're a disabled veteran, which is rare but does occur. And then they need to sign it under penalty of perjury. The homeowner's exemption is just another form that allows a nominal $7,000 off of the property tax exclusion and only saves you about $70 per year in tax. But under this new regime, you have to file that form. That's how you tell the government that you're living in the house as your principal residence, because they don't go around and look in the windows and see if you're really living there. So it's a document signed under the penalty of perjury or purgatory. Okay, so then there's a claim for reassessment between grandparent and grandchild. So in this example, the let's say the second spouse dies, a grandparent, and then the property is going to grandchild or grandchildren. This procedure will work if the child's parents are deceased. If not, there is no exclusion. So the government wants to know the details on the grandchild. Was the parent of the grandchild married, divorced, and the circumstances? There's a bit of trickiness if one of the parents was married, even though if they're not married now, it can cause the exclusion to fail because they want that middle generation completely deceased before they'll give any tax benefit. Then this is the homeowner's exemption form that you file to claim that you own the property, you live in it, it's your principal residence, and you signed it under penalty of perjury. It's a fairly simple form. Neither of these forms, the parent-child exclusion form or the homeowner's exemption form, there's no cost. You do not record the forms. You file them with the county assessor's office. And assuming you're granted the exclusion from property tax increase, then as long as the child stays in the house as a principal residence, then that rule or that benefit takes place and still in effect. If the child moves out of it, then the property tax goes up in the future based on what it would have been without the exclusion, which can be quite high. I see them from time to time from a parent or someone granting real property from one person to another, and the property taxes go up $10,000 per year from what the previous owner had. It's somewhat unreasonable at times. So they have this term, factored base year value. So this came from Proposition 13 many years ago, 1978. Sorry about that. Doing the best I can. And that was original cost basis back then. They allow it to go up 2% a year. And instead of whatever it's the assessed value, they end up calling it factored base year value. I call it the funky base year value. So we have, in a case now we're looking at where parent, surviving spouse died, and the property's going to a child, we can exclude 1 million. And this is how the computations go. You take the original factored base year value plus 1 million that you can exclude, and that's the maximum that you're going to be able to work with. And we'll go through the numbers. So example one, we have a transfer that occurs 2021. The factored base year value is 725. That means the parent's real property assessed value. And at the date of death of the surviving spouse, the market value is 1.5 million. So the computations to come up with the property tax assessed value is you take the 725 original property tax assessment plus the million exclusion, and it gets you 1.7. Then you go to the market value and you subtract that to find out that the new base year value was 725,000. So in this example, the original taxable value was 725, and the new taxable value is 725 and change. And this works out in the lower price ranges. Now, this example is an increase or an excess, so that at date of death transfer value, February 2021, the factored base year value, we're saying is 382 and change. And the market value on the date of death of the surviving spouse of 1.8 million. So we take the original assessed value plus the exclusion, comes up to 1.3 million. Then we take the market value at the date of death minus the maximums to come up with an increase of 417,000 and change. And we're going to come up with a new assessed value of the 417. The new increase plus the 382 original to come up with 800,000. So the assessed value for the decedent was 382. For the beneficiary, it is 800,000. And the way that this assessed value figures into property tax is that you're taxed at 1.1 to 1.29% of the assessed value for your property tax. So, and it goes up 2% a year for an inflation factor. So out of a large number of let's just say 1 million, then 1% of that is the property tax, or 1.1, 1.2. Okay, so this third example, we have an excess, more valuable property, and an ineligible transferee, which means either it's not a parent-child or a qualifying grandchild. So date of death, November 2021, gift to the grandson to 75%, and to a friend for 25%. So the factored base year value, in other words, the decedent's tax assessment was $250. We're saying that the market value on the date of death was $1.5 million, so that we're going to get an exclusion of the $250 plus the $1 million, or $1.2 million. And then we want to find out how much the property tax is going to go up. So we take the market value less the computed maximum, and it's going to go up 250,000. Okay, so that 250,000 needs to be allocated between the qualifying person, the grandchild, and the friend, which doesn't qualify. So in this example, we're allowing the grandchild to qualify for 375,000 of the grandchild's base year value. And when the person died, the tax assessed value was 250,000. And in the hands of the grandchild, now the assessed value for tax purposes is 750,000. Now we have another example putting in different things that could occur. We have a transfer date. In this case, we have a part of it is received by a surviving spouse. The factored base year value, which is the assessed value before death, and then an assumed market value of 2.2 million. The spouse gets 66% and the son gets 33%. So we're going to go through the computations of who gets what and what the new value is going to be. We're taking the maximum excludable of 1.4 million and market value less the maximum. So we have a potential increase in assessment of 759 and change. The son's calculation, since the son's going to own a third of the house, then the assessed value is going to be the 407. And then the spouse is going to calculate the spouse's increase in the property tax assessment, and we come out with 718,000 of the new assessed value, and that's between the difference between what the property tax assessment was before death, and 465 and change, and after death 718 and change. So it went up quite a bit. Here's another example. Trying to bring these examples in because you have to go step by step. So we had a property tax assessment, 300,000. We can exclude 1 million under maximum of 1 million under Prop 19. So we have a maximum excludable 1.3 million. The fair market value of the house, we're saying it's 1.5 million, less the maximum excluded is 1.3 million, and the difference is 200,000, which is going to increase the property tax assessment. So we took the original 300,000, added the new 200, and we come up with a 500,000 value for assessment at that point. So in order to take these tax benefits, if you do nothing in trying to comply with this law, what will happen is the property tax will be assessed on the fair market value of the date of death, and you will pay that forever, and it'll increase maximum 2% a year. You beat down the assessment by complying with what the law says you have to do. You have to complete an application. That application's a parent-child exclusion or parent-grandchild exclusion. And for the person living in the house, you have to file a homeowner's exemption within 1 year of the date of death. If you fail in these transactions, your property tax is going to be increased draconianly. In terms of turning in the paperwork for the application, you turn in both forms to the assessor. You don't record them. You have to turn in a complete copy of the trust instrument so the county assessor can read it. And the assessor also looks at if the asset distribution to see how the assets were allocated within the trust, because if you had an illiquid trust and there were some financing going on because, let's say, 3 children were supposed to get equal inheritance and there's not enough money to give each of them their cash and one of them to end up owning the house, then some more tax adversities do take place. The absolute worst thing you can do if you're a beneficiary or a successor trustee, and the trust says, okay, give the house to the 1, 2, 3 children, however many, and all you do for trust administration is prepare and file a deed stating that the prior owner has deceased. And then you ignore all the rules, and then you don't file the form that says you've lived in the house within 1 year of date of death. You never file the parent-child exclusion. And lo and behold, about 18 months after, you find out that you thought your property tax was reasonable, and now you found out that your property tax is going up, for example, $10,000 a year forever, and statute of limitation has already ran, so that you cannot correct that situation. The only thing you can do at that point, and that's the purpose of this law, is hire a realtor to sell your house. And that's why the California Association of Realtors helped create the deceptive Proposition 19 so that their real estate brokers can get a lot of real estate sales because people can't afford the property tax. And there's some motion afoot to get this law repealed. So it's a restrictive rule. It is what it is. It is the law in the state of California today. If you have any questions, you can call us and I can answer them for you. You can also email, but I prefer getting telephone calls so I can answer things easier. And there's a lot more detail that we'll be covering in future recordings.